the wrong direction. Okay, I think we just start right away and hope that the other people are dropping in. Let's start the third panel we have today, and your discussant, who is leading the conversation, will be Philip Buscher. He's from the Law Faculty of the University of Münster, and as well we have from Norway, from the University of Oslo, we have Professor Follesdal, and then we have Dr. Brzozowski from Warsaw, the University of Warsaw. So the floor is yours, gentlemen.
Ladies and gentlemen, after a nice lunch, we now continue the 4th annual international conference of the CPG here at the Lebua State Tower. Welcome back. And in this section, we will focus on a new topic, namely the question, how neutral is the state power and religious practice? And I'm sitting here with Dr. Brzozowski and Professor Andreas Follesdal. Dr. Brzozowski will start, and I will give a brief introduction in his person. Dr. Brzozowski is assistant professor at the Department of Law and Religious Denominations at the Faculty of Law and Administration at the University of Warsaw, Poland. He graduated from the Faculty of Law and Administration in 2005 and the Institute of Political Science in 2005 at the University of Warsaw. He achieved his Doctor of Law in 2009. His main areas of interest are constitutional law, law and religion, international human rights law. He is a very multilingual person, and he speaks languages as English, of course, Spanish, French, Polish, and so on. Since 2013, he's secretary of the scientific board of the magazine Law and State, which appears monthly, and it is one of the most acclaimed Polish magazines in legal science. Also, he is reviewer of the Wrocław Bureau of Law, Administration and Economics and member of the Polish Association of Law and Religion. He has published many topics. Dr. Brzozowski's presentation or speech will be about religious neutrality and the state, the Polish experience. Now the floor is yours.
Okay, thank you, Mr. Speaker. Ladies and gentlemen, let me just start, just as everyone, by expressing my profound gratitude to the organizers of this event for having invited me to this lovely country, a marvelous hotel, and a very interesting conference that keeps me intrigued during every session. Actually, now I understand what Professor Toron meant yesterday when he said that giving a speech after the lunch is a challenge. It truly is a digest session, and yet I hope I will be able to make up to your expectations. Well, the title of my paper is a clear reference to a very well-known book or work by Karl Popper, The Open Society and Its Enemies. And well, I suppose that such an intellectual loan requires both providing explanation to the metaphor and exploring its limits. So, just to start, of course, my paper, my presentation, won't have much to do with political philosophy in general, and the aim of my presentation is just to present a critical analysis of the Polish model of church and state relations as designed by the current constitution, the Constitution of 1997, and also against the background of some European standards resulting mainly from the European Convention on Human Rights and the jurisprudence of the European Court of Human Rights. Obviously, Poland as a member state of the European Union and of the Council of Europe is bound by certain standards and is supposed to observe these standards, which which are present in the European legal space. But still, when it comes to the freedom of religion, and especially to the collective aspect of this particular freedom, about the church and state relations, this standards admits a large variety of models of solutions which may be adopted at the domestic level, which makes it very difficult to look for some concrete standards. What you find are mainly some general slogans and general policy guidelines instead of concrete solutions ready to be adopted. Well, of course, I'm not intending to give you a profound overview of the Polish model of church and state relations, because I think that there are many existing contributions to this subject which are more than sufficient. They are quite easily accessible, and in addition, probably it wouldn't be of major interest to you to go into detail with me when it comes to some small details of the Polish ecclesiastical policy. What I would like to do is focus on one of the elements of the relation between the Polish state and the religious denominations, and that is the state's neutrality in matters of personal convictions. So I think it may be interesting to examine how the Polish state, with the vast majority of population belonging to the Roman Catholic Church, how the Polish state has managed to overcome the legacy of undemocratic ecclesiastical policy. Interestingly, the Polish public authorities used to be, let's say, excessively supportive of the Church before the Second World War, and then undoubtedly hostile towards religion during the communist regime until the late 80s. And this sort of defined the political and the social role of the Catholic Church, which used to be kind of political shelter for the democratic opposition and the keeper of a national spirit for many decades. So my question would be, did we succeed in stopping this pendulum swinging, just as it was achieved in the case of the Spanish Constitution of 1978, with avoiding seeking the revenge upon the undemocratic actors of the public life? Or is it like that the current constitution brought about another U-turn in the church and state relations? And I have to admit, before I move on, that the concept of religious neutrality has been made a key concept of my presentation for a reason. Because the Polish model of democracy is a separation-based one. And the Polish democracy proclaimed neutrality at the very beginning of the democratic transformation, democratic transition. Actually, even a few weeks before the right changes began, before the first three parliamentary elections. And still, I would say that it could hardly be argued that the Polish state is neutral in matters of personal convictions. And it seems to me that the religious neutrality is a missing element to the Polish public policy. So, in the Constitution of 1997, the principle of religious neutrality may be derived from Article 25, paragraph 2, according to which public authorities in the Republic of Poland shall be impartial and not neutral, in matters of personal conviction, whether religious or philosophical, or in relation to outlooks on life, and shall ensure their freedom of expression within public life. Well, just as promised, the reasons for replacing the term neutrality with the bizarre word impartiality will be discussed later on in my presentation, but I'd like to assume at this point that both terms should be, irrespectively of this obvious difference, should be treated as equivalents, should be considered equivalent. And it may be interesting to some of you that the principle of ideological neutrality, when introduced in 1989, was seen as a first element of democratic changes, that it enjoyed full political support of the Roman Catholic Church. This may be surprising, because the Catholic Church is known for being very careful about the neutrality principle, which is sometimes seen by the Church as an obvious threat. But back then, the situation was quite different, and the neutrality principle, the introduction of that principle into the legal system, was seen as a democratic change and a stop of the state's involvement in promoting Marxist ideas, which was obviously a change for the better. But still, it didn't take long for the Church, actually less than 2 years, to realize that the principle of neutrality sort of cuts both ways. That it, on one hand, it prevents the public authorities from fighting against religion, from demonstrating hostility, but on the other hand, it also implies that the state may not be involved in promoting religion and in supporting religion in the public sphere. And that is because the Catholic Church has been over the last 2 decades probably one of the most fierce opponents of that principle. Well, and one last thing. Obviously, this metaphor, this Popper-inspired term enemy, has its limits. And my intention is not to suggest that all of the actors of the public life that I'm going to talk about are enemies in the strict sense of this word, enemies of neutrality. The word enemy is a strong word which implies neutrality, which implies hostility, not neutrality obviously, hostility and aggression and willingness to cause harm. So, of course, neutrality has some enemies in the strict sense of this word, but at the same time, there are many actors to whom the idea of neutrality is something easy to neglect, or something unimportant or indifferent. And my point is that it is because of their passiveness and the proclivity to concession. The neutrality principle does not work in the Polish legal system. And going a bit deeper, it is mostly about the silent cooperation or coexistence of 3 factors. And these are the willingness to violate and ignore the principle of neutrality by the political power, by the legislative and executive power. Secondly, the reluctance to enforce the standards and to observe the standards of neutrality by the judicial power, and in particular the Constitutional Tribunal. And lastly, it is also because of the quiet assistance of some legal scholars who justify departing from the standards by interpretations which I find uneasy to accept or explain to you. So I would like to carefully examine each of these elements, each of the elements of this chain of reaction, to see how this works, or actually how the neutrality does not work because of that chain. So, starting with the political power, as far as lawmaking and law enforcement are concerned, obviously the burning issues are so numerous that it would be hard for me even to just mention all of them. So that's the reason why I'd like to just concentrate on some of them, on those which seem probably most spectacular or most instructive to me. Well, traditionally the battlefield where the regulatory ambitions of the state and of the religious communities tend to meet, this has been the religious instruction in public schools, the religious education in the public schools. Of course, whether such instruction is admissible or not, and to what extent it is present in the public school, or how deeply it is integrated with the school's curriculum, this does not have to affect the religious freedom. In fact, in the light of the European Convention on Human Rights, which sets the standards applying to this sphere, you could say that various solutions are acceptable. You may either not have religious instruction in public schools at all, you may have courses in various religions, or you may have just one course in various religious traditions combined and compared. So everything is acceptable, but at the same time, everything depends on the mechanisms designed to ensure that the religious freedom of all persons is not infringed, is not violated. So, well, the solution adopted by the Polish constitution is about having courses in particular religions, in just one religion at a time, if I may put it that way. And according to one of the provisions, the religion of a church or other legally recognized religious organization may be taught in schools, but other people's freedom of conscience and religion shall not be infringed thereby. Actually, to be exact, this possibility was recognized by the law some years before the present constitution was passed. It was introduced by means of a statute, of the ordinary legislation. So the Constitution of 1997 merely confirmed that possibility. So it looks promising, right? Because the enforcement of this cited provision should probably result in teaching many religions, and as a consequence in satisfying the needs of people belonging to various religious traditions, and or should result in enabling them to coexist peacefully in the school environment. And this, however, did not happen. And there are certain reasons for it. And as I said, we have to analyze carefully the legal mechanisms leading to this very effect. So, first of all, the obligation of the school authorities to offer courses in religion of a particular denomination depends on the number of interested pupils. And according to one of the regulations, there must be a minimum of 7 pupils belonging to a particular denomination in a school in order to apply for religious education. If this minimum is not satisfied, it is possible to combine an interscholastic or inter-school group of no fewer than 3 pupils from various schools living in proximity. Well, this creates an obvious obstacle in a country marked with an overwhelming predominance of one church, of the Roman Catholic Church, with religious minorities amounting to not more than 10%. And well, it appears that providing the pupils with a non-Catholic religious instruction is possible only in certain areas where the population, the minority population, is significant. So, according to many Polish legal scholars, the state authorities indirectly support the dominant religious group, which is the only denomination to be able to spread its teaching effectively within the framework of the public education system, thanks to the state. The limits required to organize religious instruction can be, at the same time, can be described as amounting to infringement of the principle of equal rights principle. In practice, some religious communities ask educational bodies for access to public schools, classrooms on Saturdays and Sundays. And I would say that this would be probably something closer to the spirit of religious freedom and neutrality, about looking for some wise solutions halfway, not necessarily keeping up to the letter of the law. But still, grades earned in courses held outside the educational system because of an insufficient number of pupils cannot be recorded on the final grade report. So, as a result, this fact can be seen as discriminatory. There are many more details, like the fact that the regulation that I mentioned, introducing these limits, these limits were introduced without proper statute authorization to issue the executive regulation, and so on and so on. These are technicalities, obviously, but the fact that they exist shows the scale and the number of problems somehow related to this issue. Well, moreover, the organization of religious instruction requires that the pupils or the legal guardians submit a declaration concerning the willingness to participate in a course in particular religion. And still, the law does not specify to whom such a declaration should be presented. Should it be a school principal or a tutor of the group, or maybe the religious teacher? Nor how often the willingness to assist in such a course should be restated, nor what form it should take. And this uncertainty as to the formal requirements enables the school authorities to ignore the uncomfortable declaration, which happens quite often and is sometimes reported to the public authorities, because declarations asking for providing the minority religion teachings are usually a burden for the school principal, having to organize such a religious instruction for a few persons. And in addition, there have been reported cases of the school administration requiring negative declarations, stating that a pupil or his or her parents are not interested in Catholic religious instruction, and thus admitting that he or she belongs to a religious minority, which is clearly not in conformity with the idea of secret or confession. The pupil may choose an alternative course in ethics, which is provided by very few schools. According to a survey presented in 2010, about 1% of the schools. Or decide not to attend any of these courses, which is probably about the right to laziness, which was discussed yesterday during one of the sessions. However, if a pupil decides not to attend any of the courses, such a decision will be reflected on their final school certificate, final school report, by a straight line instead of a mark against the subject religion/ethics. So that's how the school reports and living certificates, which are obviously public documents, reveal the pupils' convictions to those to whom such documents may be presented in the future, like, for example, the future employee or the high school authorities, etc., etc. And it seems to many that the pupils are sort of encouraged indirectly by the state to choose a course in religion in order to avoid identification as being non-religious or as a member of a minority denomination. And probably this situation is incompatible with a provision that says that no one may be compelled by the public authorities to disclose his philosophy of life, religious convictions, or belief. Actually, this issue was examined 3 years ago by the European Court of Human Rights in the famous case of Grzelak versus Poland, and the court found that there had been a violation of Article 14 taken in conjunction with Article 9 of the European Convention of Human Rights. This judgment obviously sparked off a lively debate in Poland, and yet, regrettably, not much has changed since then. The catalogue of legal shortcomings concerning the implementation of the constitutional rights to religious instruction could be naturally much longer. It is probably worth noticing that, contrary to early declarations, the religious teaching is subsidized by the state, which in Polish reality means that the dominant religion relies considerably on public funding. And another burning issue was another regulation of the Minister of National Education, which stipulated that the grades for the school subject religion or ethics be included in the calculation of a grade point average. So this encouraged the pupils to attend religious classes, which are usually like earning easy points in the Polish reality. The history of religious instruction in public schools in Poland is probably a good illustration of how the state effectively abandoned the idea of neutrality in religious matters and found himself somewhat entangled in supporting religion, being in practice the religion of the majority of the population. So it's not about the idea, it is rather about the combination of various defective mechanisms that brought about the state's profound involvement in religious affairs. And the public authorities are not mere observers of the advancements of the Catholic Church, but also its devoted supporters who actively give assistance to the process of the combination of the Christian faith, and that obviously includes the financial aid. Interestingly, such an attitude is also reflected in the preamble to the Educational System Act of 1991, which states that teaching and education respecting the Christian values shall be based on the universal principles of ethics. Well, and of course one could ask if the Christian values are the only values recognized and respected by the Polish public schools, and if not, why to mention them at all? Well, I would say that probably we are a bit too sensitive with issues like this, and the fact that Christian values were mentioned somewhere should be of no importance. I mean, that's just about recognition and nothing else. But the reality runs counter to this impression, because if you read, for example, the Act on Radio and Television Broadcasting of 1992, there's a similar mention of the Christian values which should be respected. Actually, it says that the public radio and television broadcasting programs should respect Christian values while adopting universal ethical principles as the basis, which is a bizarre logical combination, hard to explain, and the relation between the universal ethical principles being the basis and the Christian values being somehow different from the universal ethical basis. Well, this is probably uneasy to explain. But again, I would say that probably we are overreacting if it hadn't been for one fact. And that fact is that this provision actually worked. I mean, it was exercised because the National Broadcasting Council is authorized to control broadcasters' activity within the framework of the law, and even to withdraw the broadcast license. And this is not just a theoretical possibility, because a few years ago the Council admonished one of the broadcasters for having mocked the idea of premarital abstinence on air. Actually, it wasn't the broadcaster that mocked the idea of not having sex before marriage, but one of someone from the audience who called the radio to take part in a discussion. So this was hardly controllable when put on air. And still, this caused something that the Strasbourg jurisprudence would probably call a chilling effect, because the idea of, the possibility of being admonished for criticizing the Catholic principles of a good life is somehow scary and incompatible with the European standards of freedom of speech. And just to finish this part, in many cases, the preference towards the dominant church or the Christianity in general is demonstrated openly in the official acts of the state. The problem becomes particularly difficult if these acts are of non-normative nature, which is the case of many resolutions or appeals that reveal the official standpoint of the public powers without actually creating any legal obligations. And once again, it depends largely on the nature of such an appeal or resolution, which might be either a mild one or creating this chilling effect. Oh, that may be a problem in my case. Okay, so I'll try to keep myself brief as much as I can. After the European Court of Human Rights delivered the first judgment in the famous case of Laozi versus Italy, which will be the subject of the next presentation, and the court found that the display of crucifix in Italian public schools was a violation of the convention. A heated debate started, obviously, in many European countries, and Poland was not an exception. This judgment actually provoked an unprecedented reaction of the Polish parliament, with both chambers opposing fiercely to the court's findings. And both chambers issued resolutions. One of them said that recall the acts of hostility towards religion in times of fascist and communist rules, which is, in my opinion, an argumentation rather far from subtlety, and expressed deep concern about the religious freedom and about threats to Christianity, which have developed the human rights. And another chamber expressed a bizarre appeal calling to treat the judgment of the European Court of Human Rights with reserve, whatever this may mean. Actually knows that, actually. So, well, I would say that these examples demonstrate that the implementation of the principle of religious neutrality is an uneasy task, and apparently not a matter of great concern to the political power. But still, as far as the legislation is concerned, and not just resolutions or appeals, partiality could be eliminated by means of constitutional review. And so it could be instructive to move on to the second element of this chain, to see how what the role of the Polish Constitutional Tribunal is in reference to religious neutrality of the state. Well, actually, the Polish Constitutional Tribunal adjudicated several times upon the issues of religious neutrality, or generally religious freedom, and there is no doubt that the consistent support to the idea of religious neutrality would have helped greatly to restore the conformity of the law with the Constitution. And still, the Polish jurisprudence proves that safeguarding religious neutrality of the state is one of the tribunal's weak points, because if you analyze the judgments delivered in cases considering the issues of religious freedom, this would bring you to some rather disturbing conclusions about the strategies applied by the tribunal. So let me give you just a few examples of one of these strategies, and if this paper gets published, which I hope it does, you'll be probably provided with many more. Well, the most characteristic strategy of the Polish Constitutional Tribunal is to avoid any decision making, and that is exactly what happened in the case concerning the state budget funding of construction works of the Temple of Divine Providence in Warsaw. The tribunal waited with the delivery of the judgment so long that the Budget Act would cease to have effect, because, well, budget acts are adopted for a period of 1 year, right? And then they cease to have effect. So what the tribunal did was to wait until January of the subsequent year in order to be able to say that, well, due to the act having ceased to have effect within the legal system, the proceedings should be discontinued. The reluctance to make a decision came into play also when the tribunal adjudicated upon the regulation according to which the grades for religion or ethics should be included in the calculation of grade point average, which I have already mentioned. And well, this case seemed particularly easy because the problem was about technicalities, about the shortcomings of the statute authorization to issue an executive regulation. So in the end, it wasn't about ideology, it wasn't about axiology, it was about, as I'm saying, about technicalities. And yet, or maybe let's add one more thing. What is more important, the tribunal itself, in one of its earlier judgments, expressed the view that this particular authorization was defective, that it was invalid. So this made the applicants reduce the argumentation to a simple reference to the tribunal's own opinion. So what they did was to put in the application, well, you said it yourself. And yet, the tribunal refused to carry out the review in this respect because the tribunal found that the application lacked reasons for the claim, because the applicants failed to present their own arguments, and the reference to the tribunal's earlier statements was considered not enough. So, well, in my opinion, this looks like playing hide and seek with the applicant. And I agree with one of the justices who concluded in her separate opinion that this judgment actually amounted to a denial of justice. Okay, so just one more example of the Constitutional Tribunal, and I will move on to the last chain. Another interesting example can be the provisions on the restitution of the confiscated property of the church. That's a problem because the exact amount of damage suffered by the Catholic Church in times of communist regime cannot be determined, and the rough estimation provided by the Church is questioned by many. Still, it took the tribunal more than 2 years to decide on the conformity of the challenged provision with the Constitution, and surprisingly enough, by the time when the long-awaited judgment was finally delivered, most of the property had already been restored to the church. So the real effect, the real impact of this judgment was, well, insignificant. Okay, so moving on to the last problem, and that is the role of the Polish legal science. Well, of course, there is no doubt that the legal scholars have a role to play in this respect, because on one hand they may solve the problems which appear in the constitutional practice and provide valuable comments to latest developments, and on the other hand they may just as well ignore the legislative mistakes and offer partial interpretations and justify the infringements of the Constitution. Obviously, the suggestion that the Polish legal science as a totality opposes to that they oppose to the idea of neutrality, that would be oversimplified, because in Poland, as in any other country, legal experts strive to various opinions and they promote diverse interpretations. But still, there are many legal scholars acting as advocates of interpretations of religious freedom which could never be reconciled with the idea of religious neutrality. Or there are many who support an understanding of this concept which makes it impossible to implement. So it could be probably interesting to identify and examine briefly at least, I don't know, 1 or 2 or maybe 3 strategies in this respect. Firstly, it is not uncommon to encounter opinions that the concept of religious neutrality is quite simply not workable. So it's not possible, and therefore we shouldn't take it seriously. In that view, the state always accepts some set of values, which I agree with, and I will explain in a minute why that is so. And the conclusion would be, which I don't agree with, that the concept of neutrality of the state is logically impossible. So that introducing to the Constitution such a declaration of axiological indifference is a promise which could never be fulfilled. And some legal scholars even claim that it would be probably more honest if the state openly declared which religious convictions it supports, which is even a step further. Well, I would say that this opinion is based on a fundamental misunderstanding, because, well, of course, there is no doubt that the idea of total neutrality would be unreasonable, but nobody actually calls for such a concept to be implemented. The reason for the state to remain neutral is to defend certain values determining the nature of the political community, like the dialogue or the mutual understanding and respect for human liberty and dignity and openness to dialogue. And the state may not and should not remain neutral with respect to these values. On the contrary, it should affirm and implement these values. These values, which constitute the idea of public morality, have to be distinguished from the values of the private morality, or the so-called, as the legal philosophers call it, the concepts of a good life, being related to individual choices and to various concepts of living your life. And as far as the private morality values are concerned, the state is obliged to stay neutral, because that's probably the only way of safeguarding the democratic order. So I would say that blurring that distinction between the private and the public morality in order to question the very possibility of the state remaining neutral, that is a common strategy of delegitimization of the neutrality principle. And on the other hand, you may encounter an opinion that the Polish mutation of neutrality is somehow different from the traditional concept as it is known in the Western legal tradition. To this aim, some legal scholars put forward a disturbing idea of making a distinction between open neutrality and closed neutrality, or sometimes depicted as an opposition between the friendly and unfriendly neutrality, which is another wording for the same concept. So in that view, the Polish model appears closer to the American one, and not to, for example, to the Western European one. And it is based on the assumption that if the Polish model of church and state relations must contain some element of neutrality, then the only way out of the situation would be to redefine and reinvent the very idea of neutrality, which is a thing I could hardly agree on, because I would say that neutrality cannot be neither friendly nor hostile. It should be neutral. That's why it's called neutrality. And the problem of the scope of cooperation or basing it on separation or not, that's like entirely different matter. Okay, so I'm trying to keep myself even shorter. What I would like to say that in general, the weaknesses of the Polish legal science when it comes to the constitutional model of church and state relations obviously could be evidenced by many more examples. But I hope that the problem that I wanted to focus your attention on are rather clear by now. It's like in some cases, or actually in embarrassingly many cases, the legal scholars fail to play the role of professional guardians of the Constitution. And well, undoubtedly not all of them. I hope to be one of the exceptions. But I think that probably the future of the Polish model of church and state relations relies greatly on those ready and willing to revive the constitutional spirit. So, well, the conclusions reached so far in this presentation may give little hope for the situation to change, and well, my conclusion would be that probably neutrality is of nobody's particular concern in Poland. I don't want to finish this paper, this presentation in a pessimistic fashion, so I think that in spite of much criticism deserved, the Polish political elites have proved many times their maturity and their ability to converge on the European standards in the long run. So I hope that this will be the case of the religious neutrality, even though I have no idea how long this run may be. Thank you.
Dr. Brzozowski, thank you very much for your speech, Religious Neutrality and Its Enemies, the Polish experience. So, as you may witnessed, we now have also the Polish experience on this topic, how the state deals with religious communities. As we had yesterday, many other experiences like the Spanish experience, the German experience, the Croatian, the Singaporean, and many, many more. I will just briefly sum up this paper, and then I will lead over to Professor Follestal. So, as we heard, the Polish Constitution states in Article 25, paragraph 2, that there is neutrality of the state in respect to religion, or as it specifically said, impartiality. However, the reality is a different one, and it cannot the state cannot hardly be described as taking both the principles seriously. On the one hand, the relation-based model of the relation with the religious denominations, and on the other hand, the proclaimed neutrality. We heard many interesting examples, for example, the example of religious education in schools, and heard about many cases. And Dr. Brzozowski stated several reasons for this missing neutrality. For example, the ignoring and violation of the principle of neutrality by the political power, the reluctance to enforce the constitutional standard by the judicial power, and, as he mentioned, the legal scholars who justify departing from the standard. Yeah, well, thank you very much for this interesting input, and we will have a conversation and many interesting questions after the presentation of Professor Forster. So now we come to Professor Follestal. I will quickly introduce his person. He is Professor of Political Philosophy at the Norwegian Center for Human Rights at the University of Oslo. He received his PhD in 1991 in philosophy at Harvard University. Professor Follestal is director of the Norwegian Center of Excellence Pluricourse for the study of legitimate roles of the judiciary in the global order, principal investigator of the European Research Council, and research coordinator at the Norwegian Center of Excellence for the Study of Mind and Nature, and fellow at the Norwegian Academy of Science and Letters. He publishes on a variety of issues concerning human rights, globalization, democracy, and Europeanization. So the speech we're gonna hear is focusing on an angle of the Court of Human Rights. The presentation is called Religion and the State, the European Court of Human Rights and the Lozzi case about crucifixes in Italian classrooms. So Professor Follestal, the floor is yours.
Well, thank you so much for this introduction, and thank you to the organizers for a fascinating conference. As we have heard throughout the presentations, the relationship between political authorities and religious communities is extremely complex and extremely controversial. My contribution will be to discuss in particular the role of the European Court of Human Rights and how that has been brought in to address and resolve some of these issues, some of these conflicts, insofar as they fall under relevant paragraphs of the European Convention for the Protection of Human Rights. So our contributions, I think, mesh quite well. The European Court of Human Rights track record when it comes to regulating the relationship between public authorities and religion may seem inconsistent. It has restricted religious teaching in textbooks. It has allowed Turkey to prohibit students from wearing religious headscarves at university. It has allowed Switzerland to prohibit primary school teachers from wearing headscarves, and allows Italy to require crucifixes on school walls. Right? So there is a pattern. Right? What is the underlying theory behind this pattern of permitting and forbidding the role of the state versus religion? Now, I think there is a lot of interesting work to be done about distinguishing active versus passive uses of symbols, the permission of teachers versus the role of the church, the institutions of the schools. Another important way to approach this issue is to look at this as an example of the way the European Court of Human Rights uses a margin of appreciation, which is a particular doctrine of respecting the nation-state's own decision-making authority. So we must look at what the different state authorities said. So in the Turkish case, the Turkish authorities forbade school children from wearing the veil. In the Swiss case, it was the Swiss authorities that prohibited the wearing of veils of school teachers. In Italy, the authorities permitted crucifixes on the school walls, indeed even required crucifixes on the school walls. And in the Norwegian setting, the Norwegian authorities permitted, even required, instruction in the Christian tradition, not only information but also components that clearly had as an objective to impress upon the students, the children, religious, the Christian teaching. Now, the European Court of Human Rights granted the Turkish government a broad margin of appreciation, saying, we will let it be, it is for the Turkish authorities to decide whether this is to be permitted or not. Likewise, they granted a broad margin of appreciation to the Swiss authorities, saying, it is for the Swiss authorities to decide that to allow teachers with a veil would be undue pressure on school children. So it is for the Swiss authorities to forbid this practice. And after first having decided against the Italian government, the European Court of Human Rights then allowed the Italian government to regulate this as they wanted by requiring crucifixes. One would have thought that the court would also grant such a broad margin of appreciation to Norway, but they did not. They said, on this point, we will overrule the Norwegian authorities and say that the teaching with textbooks that are proclaiming the Christian tradition in this way is beyond the margin of appreciation. So what I'm interested in looking at then is what are we to make of this tradition of the margin of appreciation of the European Court of Human Rights? And I'm approaching this then as a philosopher, as was mentioned, not as a lawyer. But the margin of appreciation is itself a doctrine that I think merits much attention, and we can use the Lautsi case to determine whether that practice of granting a margin of appreciation, whether that is solid and whether it is actually pursued by the court in an appropriate way. So the role of the European Court of Human Rights, just to repeat for those who are not so familiar with it, is to uphold the European Convention on Human Rights and may find that particular politically decided laws are in conflict with that convention. So it is, and in particular, the court will recognize that when there is a great diversity among European states, that will count in favor of granting a wider margin of appreciation. But it still insists that the fact that there is a tradition within a European state that is contrary to the convention, the fact that there is a tradition does not in itself somehow relieve that state from upholding its requirements under the convention. So I first sketched the Lautsi case, and then I present parts of the margin of appreciation doctrine. I want to partly figure out, is it too vague, and if we try to specify it, how does it apply to the Lautsi case? And then finally assess whether that margin of appreciation doctrine actually supports the European Court of Human Rights in the case of Lautsi, and I will seek to argue that it does not support the European Court's decision allowing the Italian government to decide on whether crucifix on the wall is compatible with the convention. And I will do all of this in 24 minutes. So the Lautsi case. The Lautsi case is basically a parent who complained to the school authorities that she did not want her children to be taught by obligatory in the obligatory public schoolrooms of Italy under this with a crucifix on the wall as a symbol of torture, which was disturbing for children. And she claimed that this was in violation of the European Convention on Human Rights, that she had a right, that her children were brought up, educated in compliance with their own philosophical convictions, which was not that of the Catholic Church. The Italian government, in the first instance, claimed that this was no longer to be regarded as a religious symbol. The cross was rather an expression of the secular values of the Italian constitution, indeed representing the values of a secular life.
So, our law, is it required that they have crucifixes?
Yes.
By law?
Yes. It's not a law. It's a binding regulation. It's not technically a law. So in the first round, the European Court of Human Rights decided against Italy, saying that this is indeed a violation of the convention. There was an uproar that we heard already among 10 states, sending letters complaining to the court. The decision was appealed, and a Grand Chamber decided that Italy enjoys a margin of appreciation on this particular issue. And so I'm interested in looking closer at what is this margin of appreciation. And this case, I think, brings out how the court might use this margin of appreciation to show appropriate deference to domestic decision-making in general. So there are several elements of the margin of appreciation. That is, the court applies what in some jurisdictions is known as a proportionality test. It asks about the legitimacy of the social objective that the state pursues. It asks how important is that particular right that is allegedly being violated, how invasive that interference is in that important right, and whether the restriction of this right is really necessary to obtain those legitimate social objectives. And finally, whether the reasoning actually offered by the state is sufficient with regards to these points. So this is an interpretation of the margin of appreciation doctrine. It is a charitable interpretation of what the court says it does when it applies this margin, but as we will see, it does not always comply with its own description of how it applies the doctrine. So first, and I will go through these in some detail, there's more detail in a paper that may be distributed, which is a draft paper. So the legitimacy of the social objective pursuit. What is the objective of the state in requiring crucifixes on the walls? So the challenge then is, how does requiring crucifixes on the walls fit in with the quite legitimate interest of the state to pursue the educational objectives towards children? Not only towards it with regards to disseminating information, and a lot of information about the Catholic Church, because that has influenced the historical culture of Italy to a great extent. But the focus then is on what is permitted with regards to the teaching of religion and values and dissemination of those values in the public schools, right? The focus here is not the public sphere in general, in public arenas, but the public schools in particular. It is not a question of whether it is appropriate to have religious symbols in the public square or in the public sphere in general, but as part of the educational objectives of the state. And I want to underscore Wojciech's point earlier that the European Court of Human Rights does not at all prohibit education in the public schools about religion, but it should be objective, critical, and pluralistic. So it will allow also that in countries with a strong Christian tradition, there may be much more information about Christianity conveyed in the public school setting, as long as it is objective, critical, and pluralistic. So the question then is, what are the objectives of the Italian state when it requires crucifixes on the walls. Now, the Italian government claimed the crucifix has a neutral secular meaning. So it appears that the argument from the state was that this symbol helps convey to the pupils these secular values that are of universal application. The European Court of Human Rights, I think, correctly denounced this particular interpretation as this is not the dominant understanding of the symbolism of the crucifixes. And this interpretation was also contested strongly by several Catholic organizations writing to the court. This is just fake. So I question then first whether the Italian government has made a claim that there is a legitimate and appropriate social objective pursued by requiring crucifixes. Secondly, how important is this restricted or derogated right that a parent wants her children to not be subject to seeing a tortured man depicted on the classroom walls at all times. So this is the text of the convention, the right of the parents to ensure education in conformity with their own religious and philosophical convictions. I will not go into this in detail, but I think that is really the crucial issue. How strong a burden is this on the parent? And the question then is, how invasive is it that this proposed interference will be? The Italian government dismissed this as not interference at all because the crucifix was not a religious symbol. The European Court of Human Rights seemed to agree with the result, namely by claiming that the parent did not show evidence that this would actually impact on the children. That she did not try to argue that this would actually harm her children. She only said that she found this objectionable. Now, it is in that connection, I think, interesting to compare this case with a case I mentioned before, where the Swiss government banned teachers' headscarves, arguing that for children it would be an invasion and a problematic interference in their education if they were educated by a teacher wearing a headscarf. And the court there agreed that it is difficult to assess how much damage is done. And since it is difficult to assess, the court in that case chose to side with the government of Switzerland. So the burden of proof here seemed to shift between these two different cases. Insofar as we want to insist the court should be consistent across the cases, which I think may be a tall order for a court like this. So this is unclear. The fourth issue is whether the restriction of the right is necessary. And here again, I think Wojciech and my presentations will start to overlap a little bit. A central question then is, are there alternative policies available to the state that could avoid rights violations of similar urgency? So one would first, of course, have to ask, now, are crucifixes really necessary at all for the legitimate objective? And I've already mentioned that this is not at all clear from the reasoning presented by the Italian government. Secondly, the state did not consider alternatives that would infringe rights less. For instance, according to my sources, but there are experts in the audience that can correct me, apparently in Bavaria there are also rules with allowing the state to have crucifixes on the wall, possibly even requiring the state public schools to have crucifixes, but where as soon as some parents object, this will then be subject to a true negotiation or bargaining in that particular school or in those particular rooms where those particular children are present. So that this is an alternative that is recognizing the interest of the state in deciding these issues, but at the same time accommodating the religious rights of the individuals according to the convention. That alternative was not at all discussed by the Italian government, nor considered by the court. A third alternative, or a third issue here, is whether it is true, as it was implied in some of the discussions, that any alternative will violate the human rights of some citizens. That either the minorities' rights of avoiding this kind of religious impression will be violated, or the majority's right to avoid being subject to secular values by having no crucifix on the classroom wall. And this goes then straight to the issue mentioned before. Is it possible to be neutral on these issues? And I'm here quoting some of one of the discussions on this issue, that to have school walls without crucifixes is really just an expression of a secular worldview, which is again then discriminatory in the same sense against the Catholic religion. So in this case, it would seem if these are the only options, we are stuck with a situation where we have to violate the religious rights of someone. And in that case, the court should really be very attentive to how the domestic governments have balanced the rights at each side. I do not accept this argument. There are indeed some comprehensive conceptions of the good life of this kind, a secular worldview. The French tradition seems clearly of this ilk. But there are also political theories, and Wojciech mentioned this, that seek to establish standards for constitutions and central state institutions precisely for the circumstances where individuals have different such comprehensive personal moral views, trying then instead to develop a morality for certain aspects of the public institutions. Some people might think of this as constitutional neutrality of aims, where the appropriate picture might really be to say that the exercise of state authority should be agnostic, in as far as possible, on those issues that are controversial among the population's different conceptions of the good life. The philosopher John Rawls has explored this thoroughly, and in his parlance it's called political liberalism, that certain state institutions should have aims that are neutral as among conflicting comprehensive personal views of morality. And they should not, these institutions should not aim to favor some of these contested components of personal moralities. This is not at all saying that political liberalism or constitutional neutrality of aims is value-free, but it seeks as much as possible to not aim at values that are not shared by the substantive moral views of individuals. So this is a quite different understanding of state neutrality than the comprehensive militantly atheistic view that, as we were told yesterday and the day before. So on this view, according to John Rawls, there is no incompatibility or inconsistency between religion and democracy. This is not a version of liberalism that rejects or attacks Christianity, but it simply says these are contested objectives. Insofar as they are contested among people we want to treat as equals, we should try to have political institutions, at least a certain set of them, that do not take a stance. But this is limited in scope. It is only what may be thought of as the basic structure of society. So this would allow religious symbols as part of flags. It would allow religious symbols in public spheres, in public discussions, but not in institutions that are central for individuals as citizens. That would mean to have crucifixes in courtrooms, to have crucifixes in parliaments or in public schools would violate this sort of constitutional neutrality. So I would argue that the state, the Italian state in the Lautsi case, overlooked these sorts of alternative ways of understanding because they dismissed neutrality as just another conception of the good life, with the French tradition in mind. And I'm suggesting that this constitutional neutrality of aims is a quite different one, and it avoids the criticism that the state seem to imply. So this, again, to summarize, questions whether the restrictions of the right are necessary. So on this point again, the proportionality test was not satisfied by the Italian government. And finally, we could ask, did the Italian government actually provide reasons that are relevant and sufficient? In which case, again, judging from the case law of the European Court of Human Rights, if the court sees that there are good faith efforts by the state to attend to these different elements, the state is more prepared, the court is more prepared to grant a margin of appreciation, saying the decision of whether this policy is within the bounds of the Convention on Human Rights is for the state to decide. So whether the states actually did deliberate in what might be seen as good faith is an important component of whether the margin of appreciation should apply. And I've questioned whether the legitimate aim of the state may include hanging of crucifixes. That argument does not seem to be satisfactory, nor did the state consider less invasive alternatives. So from this point of view, again, it seems that this fifth condition, this fifth component of the proportionality test was not satisfied in the Lautsi case. So the assessment, I will have 3 minutes left. I will be selling them in an auction afterwards. What is the assessment? Does the margin of appreciation doctrine, as I have interpreted it, support the respect that the European Court of Human Rights granted to the Italian government position regarding crucifixes? I'm not now going into whether crucifixes actually violate the European Convention, but I'm asking whether the Italian government presented arguments that would make the margin of appreciation doctrine applicable to the case. And I'm suggesting no. Even if there is no European consensus on the question of the presence of religious symbols in the state schools, that is itself not enough to grant a margin of appreciation. The fact that the states disagree is not enough. There needs to be, according to the court, these components of a proportionality test. Because the Italian position fails on several positions with regards to proportionality. And therefore, my understanding of how the European Court of Human Rights claims to apply the margin of appreciation doctrine, it should not have granted the Italian government a margin of appreciation in this particular case. Thank you.
Thank you very much, Professor Forrestal, for this interesting lecture about, or speech about the margin of appreciation and how much the European Court of Human Rights should grant a margin of appreciation towards national authorities. In this case, we had as an example, the answer was that there should have been no margin of appreciation to the Italian authorities. And we learned about this proportionality test, about these 4 or 5 elements, and it was stated how sufficient the Italian authorities used them in the Lorzi case. There was the legitimacy, the importance of the rights, how intense the interference is, whether the restriction was necessary, and whether the reasons by the national authorities were relevant and sufficient. I remember that you did not disagree that there were no alternatives to no symbols, and that this was not a sign of a secular worldview if you do not have symbols in a classroom, so that might be an interesting point to discuss later. So much for my quick overview of the speech. Now I want to question and answer round, and I also have a question, but there's one speaker who has a question.
Say that I promised myself yesterday that I wouldn't speak anymore in this conference, but I hear so many interesting and insightful things that I cannot help. So if at a certain point you don't want me to speak any longer, just take the micro away from me, and that would be the best idea. If a couple of comments with regard exclusively to the Laozi case, which is something I have discussed for a number of years with colleagues in different places. And allow me to begin by explaining clearly that I don't like the Italian law, that if I could, I would eliminate, I would abolish that law in Italy. But having said that, I think that the Laozi's second Grand Chamber decision was correct. And I think that basically for one reason. Because in my view, the role of the court is not to draw, to design public policies. They don't have legitimation, democratic legitimation for that. There are other bodies with that function. Basically, the legislatures, and to some extent, with different nuances, the executive power. Both at the national level and at the international level. The role of the court is to, I have a serious judge here on my left-hand side, and if she disagrees, she would say something. But the role of the court for me is to apply the law of the land, to draw the dividing line in the case of the European Court, because the law of the land of the European Court is the European Convention of Human Rights, and is the protection of individual and collective rights, to draw the dividing line between what the state may do and what the state may not do. So you have presented very interesting arguments about the Italian policy with regard to religious symbols in the school. But I think when we look at the Laozi case, this is not what we should discuss. The discussion should begin, in my opinion, by testing whether there was the appearance of a limitation, a coercion, a violation of a fundamental right of a person. And when the court said that the plaintiffs, the applicants, didn't substantiate the existence of the coercion, I think that the court was right. And I wish that the court would have been even clearer. I'm very fond of the arguments made by the concurring opinion written by Judge Power from Ireland. It's coercion, is the text, not the subjective feeling of offense in the presence of a religious symbol, with which I may agree or disagree. You were comparing very appropriately with the Dalab case. There are other cases, as you know very well, the Leila Shaheen decisions, Dobou and Kervanchi, before them Karadouman, Boulout, after that the 6 French cases, after the 2004 law on religious symbols in the schools that were declared inadmissible. But what I think is that these were the cases in which the court was wrong, not in Laozi Grand Chamber. And I wish that the Laozi Grand Chamber decision would have been interpreted in a sort of overruling of Dalab, of Leila Shaheen and many other cases. Because I agree with you, the court was applying double standards to different cases. That was wrong by the court. And with this margin of appreciation doctrine, of course there must be a margin of appreciation for national authorities. But I think that the court in practice has been using the margin of appreciation with a lot of political messages. And to end, this explains perhaps why when I listen to our Polish colleague speak about this, taking the declaration of the Polish court, the European Court's decision with reserve, I take the European Court's decision very often with reserve, because the courts are not divine oracles, they are just a bunch of people trying to find the way.
Thank you very much, Professor Martinez Toron, for your input on this topic. So my suggestion is that we collect, and then we will answer this all in one. So I hand it over to...
if there's nobody else, because I too spoke too many times.
Thank you to both speakers, and I have I don't know, it's perhaps more a comment than a question, and I think it's really to both of you. I was really intrigued to listen to this, and partly by comparing it to some of the papers we heard earlier today and yesterday, it strikes me that there are two very different motivations for us neutrality of the state in religious matters. One is arising from a pragmatical situation where a population is divided between different religions, as for example in India or in the United States, even though we didn't hear anything about that. That seems to me very different from the motivation that, for example, comes to the fore in the French Revolution, and I think in a lot of earlier European ideas, which is very much a concern for the preservation of the political as something secular, as something that is not dominated by religious concerns. And it seems to me that, you know, one can probably argue for both these positions, but it seems to me to make sense to look at them differently. And what seems to me striking, I think both in the case of Italy and Poland, is that the way we are arguing sort of, well, let me put it like this, pretends that we're faced with a situation where there's a massive, where there's a division in the population, even though both these countries, even today, are relatively homogeneous in their religious composition. And I think this is perhaps what gives these cases a somewhat artificial appearance, because one has to make a case for very, very small minorities, very few individuals, and then of course the problem is how can you actually prove that these people are disadvantaged by the particular way religious symbols are presented, and how can you even prevent that a country or a nation that for a long time has been under the influence of one particular, almost unique influence of one particular religion, is that almost becoming cultural, as interestingly the Italian government argued in the Lautsi case, and so on and so forth. So in a way, it's not a question, it's more an observation, but obviously I'd be happy to hear from both of you, perhaps, how you see that. Thank you.
Thank you very much, Professor Zahuber, for your input. And now, Ms. Topak.
Actually, I keep saying to myself too that I speak too much, that I shouldn't, but I can't help. I agree with Professor Toro that there's something wrong with these three decisions. I would say that in the case of the first one, the Turkish case, the court should have ruled in favor of the student. By the way, these are not school kids. That case involved, I think if I'm not wrong, university students, right? And so did the Leyla Şahin case. So we're talking about young women over 18 who can decide on themselves, by themselves, what to wear and what not to wear. There's no, you don't get into this business about whether it's parents forcing them to cover. And there, I think, there's an infringement of the right to education, because in the modern world, education is a right, and so is the right to believe in a religion. And you just cannot ask people to decide between one or the other. Either choose education or choose your religion, especially adults who are able to decide both on their religion and on, what they want to wear and so on. In the Italian case, I think both the reasoning of the court, as well as the reasoning of the state, as well as the reasoning of the parents, all of it is wrong. I wouldn't agree with any of it, and that's where I differ. I think the problem here is, and that's true of the Polish problem with this notion of neutrality, and I think that's also the case in Turkey, is that there is no concrete definition of what's meant by neutrality or what's meant by separation of state and religion. And if you permit me, since there's no US here, let me give you two cases from the United States and the clause of the US Constitution, which clearly defines what's meant by secularism. There's one article with two clauses. The first clause says something like everybody's you know, free to believe in whatever they want to believe, blah, 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 like everybody else's constitution. The second article says that countries shall make no law which prefers or shows any preference for one religion over another. And when you look at Supreme Court cases, one of them is the one that, who was it? Somebody talked about in the morning, I think our, I forgot now, maybe the Iranian friend, I'm not sure who did. But this case where a group of Amish in Wisconsin, in the state of Wisconsin, refused to send their children to school, whereas Wisconsin law has it that all children until 16 years of age are required to attend school. So they took the case to court, they lost, the Amish lost, and the case went to the Supreme Court. The Supreme Court decided in favor of the Amish on the basis of the first article, that they're free to exercise their religion. And they have the right to exercise it over their children and so on, because their argument was that if their children stay in public secular schools until 16, they don't come back to the religious community. The second case involves a man in a small town, just very briefly because I think it's important. In a small town where there was a presentation of a nativity scene during Christmas in front of the municipal building. You know, Christ being born and so on. This man argues that the municipality cannot use public space to propagate Christianity over other religions, and takes the municipality to court in his state. He loses. The court decides in favor of the municipality, so he takes the court to the case to the Supreme Court. The Supreme Court overrules the decision of the local court, and the man wins the case. Supreme Court arguing on the basis of that second clause that no state authority can favor one religion over another, and that the crucifixion scene is not crucifixion, I'm sorry, nativity scene is favoring Christianity over the others, which would, I think, you know, be comparable to the crucifixion idea in schools. Obviously, I mean, it's a Christian symbol, and probably in public schools there are others other than Christians, non-believers, other people belonging to, students belonging to other religions and so on. So to cut a long story short, what I'm trying to say is that I think part of the problem has to do with the fact that in many cases, both in Poland and as far as, you know, these cases that the human rights courts considers, as well as the courts in Turkey, there's no clear-cut line as to what's neutrality, what's not, what's impartiality, what's not. You know, what's interfering with secular law and what's not. And all of these controversies, I think, are related to it. So what we need to do is perhaps do what the Americans did, you know, sort of have clear-cut lines about all of these distinctions. Thank you.
Thank you, Ms. Toprak, for your views on this issue. Especially thank you for stressing out the American point of view, since nobody will have their flag here, so we can add another experience. Now I would like to give our speakers a chance to answer all these questions, and whoever wants to start, I hand over to you.
Okay, thank you. Well, I should probably start with thanking Professor Martinez-Turon and Professor Toprak for not keeping their promises and for speaking out in this context. And well, starting with probably with the variety of the concepts of neutrality, and I suppose there will be an answer both to the question of Professor Zachube and Professor Toprak as well. Well, of course, I think that there are probably many visions or many concepts of religious neutrality, depending not only on the ideological views or the attempts to definitions, but also depending on the religious and social composition and in particular religious tradition. So the objectives of neutrality may vary depending on the religious composition of a certain state and a certain society. But still, I think that the main problem here, or talking again about the Polish experience, is that while we have many judicial tests, like for example the proportionality test, which was carried out a few minutes ago by Professor Polsdal, we have no such thing as a neutrality test in a Polish jurisprudence. And this fact is significant because it helps keeping things blurry and unclear and vague, and not knowing what the neutrality is about. Well, actually, about the US experience, I wouldn't be that much enthusiastic about the US experience because actually both clauses that Professor Toprak mentioned, the free exercise clause and the establishment clause, saying that the state will establish no religion, they both result from the First Amendment to the US Constitution. And there's not a word about neutrality in the US Constitution. Interestingly, neither in the Constitution, in the body of the Constitution, nor in any of the amendments. That's a concept elaborated on the basis of the Constitution by the American jurisprudence, and that's something I like very much about the American jurisprudence. The fact that on the basis of a few words, in fact, what they achieved was to build up a tower of church and state relations, or a wall of separation, as some legal scholars call it. So once again, it is sometimes about the political culture and the maturity of the justices. Another thing is that, well, I'd like to add one thing to the presentation of Professor Polsdal, which I found extremely interesting, and there is one more complexity to be commented on as far as the margin of appreciation is concerned, and this is the fact which seems to me that we neglect it sometimes, and we should not. It's the fact that the court sometimes differentiates between the idea of a certain margin of appreciation and a wide margin of appreciation. And these are apparently two different concepts of somewhat unclear consequences and like working on an undetermined basis. So that's probably yet another element to be examined carefully. And well, just to finish one more conclusion, and especially to Professor Martinez-Turan, as far as this treating with reserve thing is concerned, I also treat many judgments of the European Court of Human Rights with reserve, sometimes even more than reserve, and still I fail to see the role of my parliament to encourage me to take it with reserve, and that's probably the problem. It's not about just demonstrating anxiety or concern about the judgment, but about openly discouraging people from respecting the court. And I think that the direction should be pretty much opposite. Thank you.
Again, thanks for all the good comments. Just a few supplementary observations, I think, in addition to these that I agree with. So I think we would agree that the role of the European Court of Human Rights is not to design public policies. That's quite clear. But it should say whether a particular piece of legislation or policy is in violation of the European Convention on Human Rights. Right? So it's not designing. It's not somehow strong judicial review in that sense. It should be saying this is inside or this is outside what is permitted. Now, so we might be disagreeing about whether the right of parents with regards to education is only to avoid coercion or whether it is also to avoid certain kinds of undue socialization, but that would be a sort of separate issue. Now, so it is for the European Court of Human Rights to decide what the state can do and what the state cannot do. And as I understand the margin of appreciation, the court is delegating that decision to the state within this margin of appreciation. So it is saying, within a certain range, we leave it to the state to decide whether a particular decision is within or outside the scope of the convention. And then you get into these fascinating issues that sometimes there will be a wide margin and sometimes a slim margin, arguably because if there is a consensus among European states, there will be a narrow margin. I cannot understand why that should matter, but that's a philosophical issue for another presentation. We'll have to meet next year here in Bangkok for that. And it's very clear also, would political scientists say, that the court here takes clear political considerations as well, which states are subject to a wide and narrow margin.